All right. Hey, everybody. Sorry for the delay, technical difficulties, but we are all set to go now. Very excited to have Lisa Austin speaking to us today. Lisa is one of our research leads. She's an associate director at the Schwartz Reisman Institute and a professor of law at the Faculty of Law at the University of Toronto. And she's going to be talking about data protection laws concerning regulation of personal information, which is co-authored work with research lead here at Schwartz Reisman, David Lee, and two of our faculty affiliates, Nicolas Paperneau and Sasha Nikolov. Lisa is a professor, as I mentioned, at the Faculty of Law, and she's co-founder of the IT3 Lab, which focuses on interdisciplinary research on privacy and transparency technology. And her research focuses on legal theory as well as law and technology. And her extensive privacy work has been cited numerous times by Canadian courts, including the Supreme Court of Canada. And in 2017, she received U of T's President's Impact Award. And I now talk about Lisa, particularly in her work with David, as the smartest people in the world talking about how we should manage data in the 21st century. So I'm really looking forward to this talk. So you can take it away, Lisa. Thanks. And
you'd think after all this time I would know how to unmute myself. Thanks, Jillian.
I think we're unlearning, right? Like don't machine learning systems forget after a while. So I think that's so astute.
This has been an afternoon of technical problems on my end. So thank you for that generous introduction. So what I want to talk today is about a paper that's still a draft work, tentatively entitled Why We Should Regulate Information About Persons Rather Than Personally Identifiable Information. It's a collaborative paper. I'm going to be presenting it from a very kind of legally heavily perspective, being the law professor in the group. But it's work that I've been doing with David Lee from ECE, Sasha Nikolov from computer science, and Nicolas Paperneau from ECE as well. I know David had to teach at this time. I don't know if Sasha and Nicolas are here, but all technical errors are mine alone because their work is very accurate. But I'm going to really be focusing on kind of situating this work in the legal framework. And the work, the motivation for this paper came out of a lot of conversations we were having about the disconnect between what the research community and the technical side of things, and sort of computer science and engineering, how that community conceives of privacy and conceives of managing privacy risks, and the disconnect between how the law sometimes conceives of privacy and manages privacy risk. And the disconnect is concerning for a whole bunch of reasons, but a couple kind of really practical reasons are, if there's a disconnect, then the law might not incentivize best practices, but also there can be an even stronger negative impact, which is that the law can disincentivize the best practices by putting up kind of roadblocks, because there's just a different way of thinking about these issues that haven't been properly aligned. Sorry, I'm having problems with my slideshow today. There we go. The kind of cautionary tale to start with is, when you're thinking about privacy in whatever discipline you might be thinking about it in, computer science, it could be philosophy, it could be any kind of academic discipline, that there might be this disjunct between how you conceive of privacy and what privacy law, how it conceives of and protects privacy. So there's always that question I think you need to ask about, are you actually talking about apples and oranges instead of the same thing? And it's not just because disciplines have different commitments, basic commitments and concerns and considerations, but the law itself is a very practical kind of entity. So, it takes ideas, and it might think that it's dealing with kind of, universal values or technologically neutral principles, but inevitably it has to implement that in particular types of laws like legislation. And it takes up with it a lot of, the paradigmatic thinking at the time and place in which a law was implemented about what the problem was, what the technology was, what the considerations were, and you layer on top of that all sorts of pragmatic, political, global considerations of different sorts. And you might end up with something that looks very different from how you think about privacy in some other context. And so when we talk about kind of, privacy and getting better privacy protections, technically, it's not a simple matter of saying we need to figure out how to better implement legal standards, right? We need all of these technologists to just better implement the law we have. I think there's lots of questions about the law we have actually, and critical questions we need to ask. And so it's actually a lot more complicated. And that's what this research project is about, really. It's about going back and forth between, well, how do you understand this? And how do we understand this? And how can we better align those understandings for optimal protection? Okay, so I'm going to situate our intervention just really briefly in the kind of Canadian privacy law landscape. We could situate it more internationally, but just to make it more simple, we'll do it in the Canadian privacy law landscape. And just to point out, again, when we're talking about privacy law, that we can potentially be talking about a lot of very different things. So we have constitutional protections for privacy. We have privacy protection in tort law. We have data protection law. These are the privacy statutes that many people here would be more familiar with, like the Federal Privacy Act, or private sector laws like FIPPs, health legislation many of you work with, as well as a whole lot of other very specific laws that can potentially be relevant. So it's actually a large field, and what's regulated and how it's regulated differs as between these different kind of major components. The relationships between these different major components are complicated as well. So it's a complicated landscape. This particular work is really about data protection law. And in particular, if you just have it in your mind when I'm sort of talking about what we're talking about, you can think about kind of the private sector laws like FIPPs, where these are the laws that are responsible for giving you all those consent forms that nobody reads. To manage collection, use, and disclosure of personal information in commercial uses in the private sector. Because that's kind of our target. What we're saying will apply to data protection law more generally, but we're not using the other areas as examples. But it doesn't apply to these other types of privacy laws. Okay, so that's kind of where we're at. The data protection law, so if we're in data protection law, and particularly the private sector of data protection law, it's really good to know some of the basic building blocks of data protection law. Again, to understand what we were trying to propose. And the basic building blocks of data protection law, you can understand it in kind of two questions that it's answering. One, what is regulated? And two, how is it regulated? So data protection laws, again, this is like the statutes like the Privacy Act or FIPPs, or provincially it would be FIPPA. These privacy statutes, what they regulate is personal information. Okay, and globally, this is similar to, so the GDPR would be data protection law. It regulates personal data, same idea, basically. Okay, so what's regulated? Personal information is regulated. How is it regulated? The basic building blocks are understood to be the Fair Information Practice Principles, or FIPPs, and there's the canonical expression of these are the 8 principles I have on my slide. I'm not going to go through all of these in any detail. They're sort of well known, and so when you have legislation like FIPPs, it's really trying to implement these principles, right? The GDPR tries to implement these principles and then adds some more to it. Okay, so that's kind of the scaffolding through which I'm going to explain kind of what we're proposing. So many potential reforms to data protection law these days talk about adding things to these basic building blocks. Okay, and there's a lot of reforms being proposed right now in Canada. Federally, we have Bill C-11. I don't know if they're going to revive it in the new government. Provincially, we're talking about privacy reform. We had the GDPR in Europe. There's new legislation in the United States, again, on this data protection model. So a lot of kind of the new generation of data protection law is really trying to add things to this existing set of building blocks. So with respect to what's regulated, personal information, they might add some new subcategories, like, well, let's also regulate de-identified personal information in a particular sort of way. Or let's add additional principles. So the right to be forgotten, or algorithmic transparency, or in the United States, there's lots of proposals around fiduciary obligations, for example, or we could say data portability. Anyway, there's additional kind of new, let's call it sort of newer generation principles to add. So a lot of these reforms are kind of, I want to call additive. Our potential reforms and what we're proposing is to change actually the basic building blocks, to really change the architecture of data protection law. And so what we want to say is that we should change what's regulated. Instead of regulating personal information, we should change that to, we should regulate information about persons. And we'll explain this in a minute. And with the question about how is it regulated, instead of just adding to the FIPPs, we say we need to actually start revising these principles. So not just add to them, but start to revise them. And the one principle that we focus on in this particular work is the collection limitation principle, which we argue should be changed to a privacy risk minimization principle. And then the other principles should also be scrutinized and revised. We say a little bit about it in our draft paper, but we don't get into a lot of detail. So that's just to give you a picture of what we're proposing in general as a reform to data protection law. It's not about adding things to an existing framework, it's about changing the framework. Okay, so then I want to explain why. Why should we change that framework rather than simply add some of these new obligations? Okay, now this I'm going to go through. This might be very familiar to some of you who work in the privacy space or have worked in the privacy space, but if you haven't, it's sort of important background. So there are a series of problems with the whole basic architecture of data protection law, because remember, with a question to what is regulated, the answer was personal information. And that's understood to be identifiable information. So identifiable information is what's regulated, and traditionally it was thought anonymous information is not regulated. So the gatekeeper, are you in and regulated, or are you out and not regulated, was this idea of identifiability, and is this idea of identifiability. Okay, this has been criticized for a long time now. A very famous article by Paul Ohm talked about, this whole kind of legislation resting on what he called a robust anonymization assumption. This idea that you can anonymize information in this sort of robust way, and then it wouldn't be regulated. Sort of like get out of jail free card, he called it. And the problem was it's challenged by what he called the easy re-identification result. And what was the easy re-identification result? A whole bunch of basically high profile examples. Many of you know these examples where information that was assumed to be anonymous was actually subject to re-identification in different ways. So there's a ton of these sorts of examples. Some of it being publicized from the New York Times, Twitter data that was supposed to be anonymous but had metadata attached to it could be used to identify people, health records that were released in Australia that were supposed to be an anonymized data set were re-identified. The Netflix Prize database famously was supposed to be anonymous information, and people were re-identified in it. So there were all these different re-identification attacks that were shown that this robust anonymization assumption just didn't hold. So you have a regulatory regime that's based on this idea that you can distinguish between what's identifiable and what's anonymous. And you have all this computer science research saying, wait a minute there, not so quick. Okay. Despite that, so I find it very interesting when I talk to friends in computer science and engineering, they're like, yeah, that's just a dead paradigm, that whole idea of anonymity. But in my world, it's not dead at all. So here's just a couple examples. The recent online public consultation for modernizing Canada's Privacy Act, this was put out just last year, says, and I quote directly, despite some well-known anecdotes of de-identified personal information being subsequently re-identified, the use of de-identification as a privacy-enhancing technique is well supported, even by regulators. So those were all just anecdotes, and actually, we can rely on de-identification. Same with that, and here's a quote from the Information Commissioner's Office in the UK, saying that we can achieve effective anonymization. Okay, so what's responsible for this disjunct between kind of the research world and the regulator's perspective? I think that, so this is my best guess as to kind of reconstructing what's going on in the heads of regulators when they say, actually, we can support de-identification in some forms of anonymization. And what I think is it's a pushback against the kind of characterization of anonymity that you see in work like legal scholars like Paul Ohm, or just in some of the technical research. And that is on a couple of grounds. The legal threshold, when we're talking about identifiability as, again, the gatekeeper for this kind of act and legislation, it's not about the possibility of re-identification. It's about the serious possibility or the reasonable expectation of re-identification. So proving that something is possible to re-identify doesn't meet the legal test. So what you have to show is that there's a serious possibility that something can be re-identified. So that's one source of that kind of disjunct. But another one is that a lot of these re-identification attacks were focused on data that had been publicly released. And so we sometimes call that the release and forget strategy. So you release data and then you just forget about it. You don't do anything about it. And that kind of data is, especially when it's got individual records, is easy, susceptible to re-identification attacks. But what we see the regulators endorsing are strategies that aren't about release and forget. It's about de-identifying the personal information, so trying to remove obvious identifiers and indirect identifiers, but then you're releasing it to specific parties, right? It's a managed release. It's not release and forget. It's not public release. It's a managed release to specific parties, and that allows you to manage the residual risks through data sharing agreements and organizational arrangements. Okay, so I call this the managed anonymization assumption. Okay, so that's better. The managed anonymization assumption is better than the robust anonymization assumption, but it still has some problems. And I want to kind of walk through some of these problems. So one problem is that it still means that you're managing privacy risks through definitional interpretations. This is just a weird way of doing legal regulation. Okay, I'll say a little bit more about that. And then on the second point is that on a technical level, it still incentivizes the wrong approaches to mitigating privacy risks. Okay, and I'll talk a bit more about that as well. So, but I think this managed anonymization assumption is what really the regulators are working with. Okay, so managing risk through definitional interpretation. So basically still, if what you have is a legislative regime that says if it's personal information, you're regulated, if it's not personal information, you're not regulated. But what you say is that identifiability is really a spectrum of risk, right? There's a spectrum of the risk of re-identification, and that managing those privacy risks is a process, right? How it involves kind of ongoing monitoring. And that these risks are kind of, systematic, then it's still very strange to try to manage this risk through a determination of you're in or you're out, right? You're using this, yes, it's personal information and you're regulated. No, it's not personal information, you're not regulated, to try to map onto what is this, spectrum of systematic risks that requires a process of managing. And so through definitional interpretation, you're actually managing risk. This is a very bizarre strategy for legal regulation, and it doesn't work particularly well, in my opinion. And I want to say a little bit more about the systemic privacy vulnerabilities, because I think this is a real issue in that the FIPPs framework, the Fair Information Practice Principles framework that the data protection law is set up to manage, is really about protecting individual control over personal information, particularly in the private sector versions of it. And it never really was a model for addressing systemic privacy vulnerabilities. But really, when we start looking at risks of re-identification, that's what we're looking at. And I just want to pick out three. Again, this is going to be sort of old hat to people who work in the space, but maybe not if you don't. I want to look at context, time, and what we call in our paper the rounding problem. So context is an issue about where re-identification risks are dependent on the context. So it really depends how you figure out whether something's at risk for re-identification. You need to figure out, well, who are your adversaries and what information do they know, as well as know the abilities and their motivations. So there's a ton of context. And that makes it very difficult to regulate risks at any kind of scale, because if you say everything is so context specific, and for example, in Europe, the Article 29 Data Protection Working Party says in their guidelines on anonymization, the optimal solution should be decided on a case-by-case basis. So again, if you're trying to come up with sort of approaches to regulating privacy risks that can scale in the way they have to scale these days across very complicated data ecosystems, deciding optimal solutions on a case-by-case basis with all of this contextual information becomes a very difficult strategy for regulating. The time problem is also that, at a particular point in time, you might think that something is not personally identifiable information, but technology changes, business models changes, and tomorrow it might turn out to be personally identifiable information. So again, there's a sort of temporal element in how you manage this. And so you don't have this fixed line, and so you need to know a lot of context, but you can't even peer into the future and understand what those risks are going to look like. And then there's something we call the rounding problem, which is just another way of talking about systematic risks. So we round numbers in order to kind of reduce complexity and make numbers a little bit more manageable. And so, similar, that's what we're doing when we say, well, we have a spectrum of risks of re-identification, but we're gonna, to simplify matters, categorize things as identifiable or not identifiable. The problem is, you can see here's the rounding problem. You can take a series of numbers and round them all to 0, but when you add them together, they actually total 1. So you're going to get the wrong total. And so if you sort of draw that analogy around a kind of identifiability risks, you might say, oh, this particular data identifiability risk doesn't meet the threshold for the legal regulation. And then, you have another set of data doesn't meet the threshold, another set of data doesn't meet the threshold, but you might actually, in putting it together, meet the threshold. And so figuring out how to manage that risks when you're using a model that's very kind of, based on a particular organization and whether they, in their particular use at a particular time in a particular context meets that threshold, you're not going to get at those systemic risks. You're just not going to manage them properly. Okay. So what we have, the FIPPs model, is really what, this is a quote from Julie Cohen, another legal scholar at Georgetown, is an atomistic post hoc assertion of individual control rights. This is really what kind of FIPPs is about. But what we need with privacy law is to discipline networked processes that operate at scale. We need to be looking at how to regulate systemic risks, and the FIPPs framework is just kind of not well suited for that as it currently is structured. Okay. And I want to say a little bit about sort of technical approaches to privacy risks as well. I'm not going to go into the sort of details on explaining what differential privacy is, or what homomorphic encryption is, or what trusted computing is, so much as I want to show why it's a bit different from the focus that privacy law has on identifiable data. Once the privacy laws focus on identifiable data, then the flip side of that is to look at information that either is considered anonymous or de-identified. And the focus of that, as I sort of pointed out in the managed anonymization kind of paradigm that I think regulators work with, is that you manipulate the data as much as you can, and then you right through de-identification. So you strip obvious identifiers, you might suppress certain kinds of information, you try to manage indirect identifiers, and then you can share the data, but you want to manage that sharing with things like data sharing agreements. But technical approaches are quite current ones that are getting a lot of research and development are quite different from this. So differential privacy, for example, and again, I'm not going to explain differential privacy so much as explain the contrast. Differential privacy doesn't focus on removal or minimization of direct or indirect identifiers. It focuses on how the data is processed. It's not about identifiability either. So the privacy risks that it picks out are whether you're learning information specific to an individual. So if I learn something specific to, record 1, 2, 3, I'm learning something specific to an individual, even if that individual is not identifiable. So it's not as tied to ideas of identifiability, and it's definitely not tied to these data manipulation techniques of removing or minimizing direct and indirect identifiers. Homomorphic encryption also is kind of a weird fit with some of the kind of standard ideas in data protection law, because it allows us to perform computations on encrypted data without decrypting that data first. And so this is really interesting. So if I'm sending you encrypted data for you to do some kind of computation on, have I disclosed personal information to you? I don't think I have, even though I've sent kind of data. Are you using personal information? Well, sort of, right? You're doing a computation on it, but you have no access to it. So you're not really using it in the way that data protection law is worried about the use of personal information. So it doesn't quite map onto the sort of legal categories and ways we have of talking about data and privacy risks. And it's definitely not about de-identifying the data. And trusted computing, we can do a lot with the computing, with the hardware and the computing environments that can also mimic what homomorphic encryption can accomplish, and can also provide, more traditional types of controls around auditing and access controls. Okay, so you have these different, the point is these different technical approaches aren't necessarily mapping onto what the regulators are thinking about when they're thinking about managed anonymity. And the benefits of these new technical approaches are really quite high. So you can protect privacy with fewer detrimental effects on accuracy. Why? Because the focus is not on manipulating the data, right? So when you're de-identifying, you're removing aspects of your data set. So, and again, there's trade-offs in all of these technical methods, which my colleagues are the ones to ask about. The differential privacy gives us a way of determining and measuring privacy risks without needing to take into account contextual factors. A lot of these methods, especially if you start putting them together in different ways, can provide potentially higher privacy guarantees and better abilities to audit data flows as well. Okay, so these are just some of the benefits. But they don't map onto, as I've been saying, the managed anonymization kind of approach very well. So managed anonymization is a focus on manipulating the data, right? You de-identify it, then you release it in a managed way. You mitigate the residual risks of release through things like a data sharing agreement. And that just doesn't map onto these technical approaches to privacy risks, because instead of manipulating the data, we should focus on methods of data analysis, right? The algorithms, not the data. We should focus on preventing data flows, not releasing data, but not releasing the data. So whether through encrypting it or providing kind of access within a secure computing environment. So we can have different ways of thinking about managed access instead of managed release. And we can do this without having to dial up this manipulation of the data and still potentially achieve better results in terms of protecting privacy. Okay. And then, so that's the kind of looking at, that first question in the data protection law context, which is, what is regulated personal information? And then the second question was, how is it regulated? And I said it's regulated through the fair information practice principles. And there, one of the substantive principles that also has a problematic approach to privacy risks is what's sometimes referred to as data minimization. And data minimization is an obligation that comes out of the collection limitation principle, but also other FIPPs principles support it, but for simplicity's sake, we'll just focus on collection limitation principle. But you can see just by even the name, the idea is that you limit the collection of personal information. That's how you're going to manage privacy risks. It's focused on collection and not subsequent processing of any sort. And it's focused on the data and not things like how we analyze the data or provide access to it. So data minimization is often, people, when they talk about complaints about the focus on consent, they say, well, we need to not just focus on consent, we need to focus on data minimization as a way of really helping to minimize privacy risks for people. Data minimization is the wrong paradigm. It's also not going to align itself with where I think the technical approaches are taking us and taking us in a good way. Okay, so with those sort of ideas in mind, what should regulatory change look like, again, in the context of data protection law? So this is just the slide I showed before, again, just brought back now. So our proposal is what's regulated, stop focusing on personal information, because what you're doing is effectively regulating risk through figuring out definitional interpretations. This is just a perverse way of regulating because in effect, you're imposing all sorts of obligations around managing re-identification risks, but you're not doing it in a very clear way. You're not doing it in a way where you're creating clear standards. You're doing it in a way through kind of statutory interpretation of a definition. And that's just a bad way of doing it. And then, so we say, change it to regulating information about persons, which is, yes, a broad definition. And then impose a privacy risk minimization principle. So if you're going to be processing information about persons, you need to minimize privacy risks. Okay, and that should be the principle, and focus away from the collection limitation principle and its focus on data minimization. Okay, so just to give you a sense of what that contrast would be in terms of the data minimization change. So on the one side of the slide, this is the kind of standard formulation of the collection limitation principle. There should be limits to the collection of personal data, and any such data should be obtained by lawful and fair means, and where appropriate with the knowledge or consent of the data subject. Okay, so we're saying split this. What you need to do is pry apart the question of authorization. So, right, any such data should be obtained by law and fair means, and where appropriate with the knowledge or consent of the data subject. We're calling that the authorization principle, right? Data uses should be authorized. But that should be a separate principle. The authorization is a different idea than kind of minimizing privacy risks. And the limits to the collection of personal data, that data minimization component, that's what we say should be transformed into a privacy risk minimization principle. And in the paper, we go into more detail about what does it mean to use privacy protective techniques and safeguards. That would be that sort of suite of tools of sort of the techniques I outlined. And the main point there is it can include de-identification if the if the use is called for. But what the change is that that's not the default. That's not the default, which is what it is now, where you dial up de-identification as much as possible and then figure out if you can manage the residual risks in some other way. Instead, you have a suite of techniques, and that might even be way more privacy protective, that don't require so much data manipulation in order to minimize privacy risks. And we go into a fair amount of detail in the paper about how you're going to define privacy risks as well. And we basically adopt the approach that differential privacy takes to it. So we sort of mimic that understanding of what it is to minimize a privacy risk. Okay, and then we say you separate out the authorization principle into a separate principle. And I'll take questions in a minute. I know there's a lot more sort of to this. On one of the previous slides, I mentioned that you still need to go through the rest of the FIPPs principles and say, okay, what needs to be changed about the rest of the architecture? And we go through that a bit in the paper. The paper doesn't come out with a full kind of view of how to reform all of FIPPs, and that's partly because to do so requires a lot more thinking about kind of what your normative commitments are and what your regulatory goals are beyond kind of managing privacy risks in the way we're proposing. So, and we don't take that on in this particular paper, but we make suggestions about what that might look like. The one thing I do want to say about kind of, a speed bump in all of this is there's still an issue about context. And the issue about context is this. So if instead of data minimization, we're talking about privacy risk minimization, it's still risk minimization, not elimination. And you still have that question of what level of privacy risk is acceptable. And it's hard to think how you're not driven back to some kind of determination of context, right? That privacy risks when you're dealing with medical information might be less acceptable than privacy risks dealing with some other type of information, right? That are you going to end up back in this kind of contextual sort of quagmire that the current regulation and the way it's set up always seems to develop. And so we play with this a bit in our paper, and we're still sort of thinking about this. Some of the proposals in Canada, particularly federally, have introduced ideas of codes of practice, which could allow for context-specific rules. There's experience with this in Europe. So, for example, you'd have a sector that would develop a code of practice, have that approved of by the regulator, like the privacy commissioner, and that would allow for sort of context-specific rules, but you could rely upon them. And, although this is promising for a variety of reasons, we say that's not going to really answer the question of kind of incorporating best technical standards, or at least we have to think about how to make sure that the codes of practice would develop in that way. And the reason for this is you can imagine that you have like, codes of practice for online advertising and code of practice for sort of, banking. And so you have these sector specific rules, which is generally how they work in Europe. But really, you're going to have different components of it that deal with certain kinds of data practices in very specific ways. And it might be that, some of those change and we have new understandings of what it is to minimize the risks associated with those practices. And those practices might be used in multiple different kind of codes of practice. And so you need still a way of figuring out how technical standards for kind of more specific components of data practices fit into codes of practice, and how those technical standards can be developed and updated in sort of agile ways. And so there is this need for sort of context-specific rules in figuring out what level of privacy risk is acceptable, but figuring out how that's going to work with technical standards is still something that we need to work on. But is where I think you might actually get better regulation if we can sort of crack that nut. So And I will leave it at that, although I glossed over a lot of details, but I'm happy to answer those details in questions.
Thanks, Lisa. That was terrific. Sorry, let me just adjust my view here so I can see everybody. And as many people as possible, turn on your camera so we get to see everyone. Just want to encourage that. Terrific. Anybody want to start us off? Anita.
That was amazing, Lisa. Your encyclopedic knowledge of this topic is hugely inspiring. Thank you so much for that fascinating presentation. I wanted to ask you if you've had a chance to think about or had some analysis of or exposure to issues of interactions across jurisdictional boundaries, either embedded jurisdictions like the city inside the province, inside the federal government, or relationships between jurisdictions such as California, the impact of California on other states in the United States, for example.
Yeah, and I think that when I've spoken with other colleagues in other countries who are also really concerned that we get better technical standards and practices adopted, is there a way in which you can have these standards recognized by multiple regulators? And I think that's pretty promising idea. How you figured out how to do that is an interesting question. Like we don't tackle that in this paper, although we talk a little bit about, there is some research and some sort of suggestions starting. There's some work by a colleague in law in the United States, Ira Rubinstein, who I've been talking with about this as well. So I think that we're going to have different laws, and the laws are going to do different kinds of things, right? The scope of consent is going to be different. The exceptions are going to be different. The ways in which certain kinds of values are balanced are going to be different. But I do think that there can be some kind of core elements in terms of, technical ways in which we understand risks, where we can come to some agreements on. I think you have to kind of do it in a more modular way like that. And that then you can say, well, we accept that this is an acceptable way of, merging data for the particular, in this particular way, for this particular purpose. And then you can have multiple regulators say, yeah, we agree with the standards that this particular body accepts. And I think that's a way in which you can then create systems that can work in multiple jurisdictions. Whereas if you're gonna again do this sort of highly context specific and then figure out within each particular law, which is going to be slightly different too, it's a nightmare, right? So we have to figure out some of the common components and figure out ways of getting people to agree on those components.
Do you think we need an international body to establish like some sort of a international framework?
It might be, right? It might be that some kind of international standards body. I mean, some of those work really slowly too. Like, I mean, I don't know enough about some of the literature around setting national standards or international standards. Some of those bodies can be incredibly slow themselves and politicized and others, but something like that, right? Some kind of independent authorized body that could be recognized then by multiple jurisdictions. Even within Canada, that would be useful because we have all these different privacy laws and different regulators.
Great. Thanks, Anita. Tegan, I see you had a question in the chat. Did you want to ask that?
Sure. Thanks for a great talk. I wrote in the chat, I don't know if you read it, but I'll just read it. What do you think we should do when risks change if we're using this framework? Like, for instance, a data breach in one area could significantly change the risks for another area.
Yeah, so I think that the reason I like the move that, for example, and this is my opinion, not my colleague's opinion. I should sort of preface everything I say in answer to questions. I think that with respect to the sort of, codes of practice kind of move that we're seeing the federal government make, is responsive to the need that organizations have to rely upon something. So we need to say, this is an acceptable way for me to sort of, organize my data practices, and I can rely upon that. And if something goes wrong, I wasn't negligent. Don't find me big amounts of money. I wasn't negligent. I wasn't irresponsible. But then we also need ways of updating that in light of new information, right? And so I think that, again, you can have sort of these ways of saying this is an acceptable risk at this time. We learn something new and we update that, and now we have to change our way of doing things and our advice. So I mean, we do this. To give you an analogy, we do this in law all the time. So if someone wants a legal opinion from me, I look at what the law kind of currently is, and I say, yeah, I think you can do the following because this is my interpretation of the legal authorities. And then some new case comes out. And it turns out, oh, the thing you thought you could do, actually you can't do in the way you thought, right? So you're going to change your advice, and you're going to sort of, go back and say, well, actually now there's a problem. And so we do this all the time. So we just need a way of integrating that information, right? And updating practices and updating what the kind of acceptable standards are.
I thought that makes privacy different is that sometimes it might be very urgent, and the kind of like case law, like, oh, okay, next time we'll make it different, or we'll start the process, and in a couple of years we'll have ironed all the details out. Like, it might not work if it's like medical records that are now totally transparent to anybody who can look at them because of a data breach at like Facebook or something.
Yeah, no, fair enough. The question of sort of doing these things in agile ways is a problem. But again, one of the things we're trying to say is that you need to approach privacy risk minimization in a systemic way, and across the kind of ecosystem, across multiple organizations, as a way of kind of tamping down the potential for some of these catastrophic losses. So it's still better the way that we're proposing to do the minimization than I think what you have now.
Yeah, can I just jump in on the urgency? So Lisa and I worked on a sort of an effort around the pandemic. Can we quickly figure out some adequate ways to get some data aggregated so we could start using some machine learning tools? And I guess there was a study that came out recently that said they were like something like 300 AI powered methods that were developed to help address the pandemic, and only 2 of them actually ended up with any clinical application. And it was really a lack of adequate data that drove that. And what we saw as we were trying to work on this was that these existing approaches that Lisa was talking about just made it impossible to collect the data, even with the urgency of trying to build things around the pandemic. So that's where I learned everything from Lisa, by the way, was working with her on that. Daniel.
Hi. Yeah, thanks so much, Lisa. Anita mentioned that you have an encyclopedic knowledge of this area, and I feel like I have like a skimmed Cole's Notes knowledge. So it's like it's very good to get this kind of background. And so I have to kind of use that as a preface to kind of admit that my question might be a bit naive. But so I'm still trying to wrap my head in many ways. Like I've had conversations with friends about data privacy because I don't feel the same concern I think that I see a lot of people have about this topic. And one thing that I thought was interesting is I saw a Pew survey from 2019 that was looking at American adults. And in the survey, they had 66% of US adults believe that the risks outweigh the benefits in terms of the data the government collects. And at the same time, 78% of the people surveyed said they didn't know, they had little or no understanding of how the data was used. So it seemed like there's like this disconnect. And doing a fellowship in municipal government in New York this past summer, I used a lot of data like American Community Survey data, which was amazing and really great and like critical for developing policies and seeing how policies are working. And so I feel like the tone of a lot of the coverage seems alarming, and I don't exactly know. And you mentioned the word like the adversary. So I'm not sure like who is the adversary, what should we be worried about? And is there any kind of like metric about like how great the cost is, like on an individualized, annualized basis? And am I worried about fraud? Is that the main concern? And in the end, I feel like my feeling is like I want better data security more than I want more data privacy. I have LinkedIn, I have Facebook. I don't really have data privacy already, but I don't like the idea of there being a breach. So I feel like I would like that to be addressed, but I have very different feelings on data privacy.
And so lots in there. I think that, I mean, part of what we're responding to in this particular paper is trying to pry apart two different ideas. One is managing privacy risks, and the other is what we've called sort of the authorization principle, which would include consent, right? And so in a lot of privacy debates, they tend to come back to consent. And the Canadian framework in the private sector is, consent is the starting point. So if you're dealing with personal information, the individual has to consent to it. But what happens is, so that might make sense if it's, information about me specifically. The idea is, right, you can only collect it, use it, and disclose it if I say it's okay. So I authorize basically the kind of the data flow, and then we manage the integrity of that data flow, right? You can't use it for some purpose I didn't say you could. And that supports a whole set of values around, I mean, people parse this in different ways. Autonomy, identity, et cetera. We can sort of go into that in various sorts of ways. The problem, I think, is that the figuring out what are you entitled to kind of authorize, right, has become bound up with this question of kind of basic risks. And so, you're loading all that risk regulation onto individuals when you can kind of pull it apart in different ways. And so our approach is to say, look, there's all these various sort of systemic risks in how we're managing data. So let's just, responsibly manage data, but the individual is not, the one monitoring that. You have this obligation. The regulators are going to make sure that, your systems are kind of managing this in a reasonable way. And that might allow us, I mean, we don't argue for this in the paper because, again, you'd have to bring in a whole set of other kind of normative commitments, but it could very well allow for the shrinking of the scope of consent to things that we might think are kind of more aligned with your intuitions about the things that really matter to you or don't matter to you. It doesn't necessarily mean that you have to shrink consent, but it could, right? It's consistent with doing that, because we're trying to say that, the question of what you should be authorizing as an individual around data is separate from this question of kind of managing systematic risks around data. And the systematic risk idea, I mean, an analogy you can think about is, so when, you go out driving, there's all sorts of things that are regulated around the safety of your car, around the speed limits, around, using a seatbelt, et cetera. And it might be that, it's not necessarily the case that anytime you drive down the street, you're going to be in an accident or come to any harm, or that there would have been even a problem if you didn't have that seatbelt on, or if you went over the speed limit. But we impose all of these different things generally in order to make driving safer more generally, right? So there's reasons why it's good to kind of, sort of, bring the level of risk in, say, the data ecosystem down generally, but to pull it apart from some of those more individualized concerns about what's the scope of privacy rights and what are the harms we're most concerned about. And so our architecture, we don't address those other questions that you're sort of raising, but we indicate kind of where they intersect with our framework, and how the framework might affect how you answer those questions.
Nicola had a comment in the chat. I don't know if you want to throw that in here, Nicola, or people can read it there. I'll take that as a read it in the chat. Okay, Mohammed.
Sorry. I'm
Okay. You're there. Okay.
handling hybrid meetings with real people coming in the room and Zoom at the same time. Sorry.
Right.
Could you repeat your question?
Oh, no, I was just going to say you had a comment about privacy and security. I thought you might just want to add in response to Daniel's question.
I was also typing a follow-up. Basically, what I was saying is that security is sort of a foundation that is required before we can achieve privacy. And I like that Daniel sort of separated the two, because very often people confuse security and privacy. For instance, all cryptographic techniques allow us to achieve security, but don't protect against the leakage of private information, for instance. And so when we are having, in the case of machine learning, a decentralized deployment of machine learning that provides the foundation for security, but it doesn't provide privacy in the sense that it doesn't limit how much private information leaks through the application of the algorithm. And so I think my assessment on sort of why privacy matters, once we've said that, is sort of privacy is already lost. There is a lot of private information that is published about us in several ways, online and offline. And so the question that's interesting in privacy research is, how do you develop algorithms that we are about to release, essentially, while understanding how much information they extract from the data that they process, and whether extracting that information is actually necessary to solve the task that these algorithms are trying to solve. And very often we're basically doing, by default, designing algorithms that extract more information than they need to actually solve the tasks that they're trying to solve. And what this means is that we accumulate more and more private information that we do not need indirectly. Basically, we accumulate this information through the application of the algorithms. And then once we later realize that we don't want this information to be public, then it's too late, essentially. So it's more of a proactive thing. And then in terms of why, like sort of examples of leakage of private information, I think it's more common to see examples of data breaches, just because there's no way around discussing those publicly. I guess there's no way around not discussing those publicly, but I guess in between the lines, you can sort of infer from different stories sort of that there is possibility of private leakage. It's just, it's not discussed a lot in the public.
Great, thanks, Nicola. Mohammed.
Yes, thank you first for the talk, a very interesting talk. So I wanted to talk about DP in particular in computer science and like trustworthy machine learning. We have this tendency of parameterizing these measures, including differential privacy, including various measures of algorithmic fairness, and sort of putting off the choice of these parameters, which is very essential, onto regulators and lawyers and whatnot. I wanted to first get your response on whether this is even realistic, whether there's precedence for that, whether we should continue doing that or not. And the second question, which is related to what Nicola was just saying, is that DP allows for defining a privacy budget, a metric or a score that you can track throughout someone's life, very similar to a credit score. But this time not being lured by, for example, the person itself, but by whomever wants to use that person's data. So do you think this is a reasonable suggestion? And do you think that it can be respected or even mandated by law in some level, so that it's very similar to how lending and financial debt, for example, is handled through regulation laws?
Thanks, those are interesting questions. So around the choice of parameters, so yeah, I'd have to think more about that. but one of the, I think it gets back at that kind of tension I was mentioning at the end of the talk, which is, you know, on the one hand, if you have sort of a, just to put it really, really crudely, suppose you have some kind of, you know, technical approach to privacy risk, and they say, okay, if we do it this way, you know, the risk is 3, and if we do it this way, the risk is 5. So what do you want, 3 or 5? And that's going to depend, right? You're going to say, well, that depends on the context. So you need to tell me, you kind of, you know, lawyer interpreting this or regulator interpreting this. And I think that there is a kind of inevitability where some kind of judgment like that has to come into play. The question is kind of what's the interface for that, right? So I think part of the problem with using a paradigm that's focused on identifiability or personal information is that everything is like contextual, everything is up in the air. You never, like, you can't create any kind of standards around that. So, and it's just so open to discretionary judgment at every step, right? That you can't get anywhere. You can't get anywhere to creating proper technical standards. You can't get anywhere to creating standards that you might have multiple jurisdictions buy into, right? You just can't get anywhere if everything is like, it really depends on what, you know, every case has to be looked at in its own specific context. So the question is kind of like, how do you build that kind of interface between the judgment of, okay, who gets to decide, is it 3 or is it 5? On what basis, and then how do we decide, well, you know, if you do it this way it's 3, if you do it this way it's 5. And you know, I'm not sure what that looks like, but we do need something more like that than what we have now, which is, you know, just this I think an unworkable basic architecture. With respect to the privacy budgets, like I don't know much about that particular proposal. I'd love it if you have a link or something, or you can flip me in email. I'd like to hear about it. There are so many proposals right now that are really focused on individuals. So if you take the FIPPs framework, and which is about individual control over personal information, there are a lot of proposals that are about strengthening that individual control over personal information in various different sorts of ways. And you know, they're worthwhile projects and worthwhile thinking about. But this project goes in a different direction by saying that that focus on individual control over personal information is not a way of managing systematic risks in a complicated data ecosystem. And so it might be that some of those proposals have a place, but they are not the solution, because the solution is going to have to manage this other problem. And so that's why I was saying we're separating again, data minimization from authorization, and then transforming data minimization into a privacy risk minimization principle. And so yeah, there's lots of proposals that have some flavor of let's you know, dial up the protection for individual control. This is not a proposal about that. This is about something quite different. This is about, that does not address systematic privacy risks and the systematic privacy vulnerabilities in the data system.
So smart, so smart. I'm going to go to Christine, who had a question earlier in the chat, and I'll come to Michael and Sheila. Christine, please.
Good afternoon, everyone. Good afternoon, Lisa. Thank you for your presentation. My question, I'm from Chile. I work at the Congress in Chile, and we're currently discussing a new privacy law. And at the same time, I'm participating in a regulatory sandbox, the first one made in Chile on AI. So I was reading, and this is how I came to the realization that in Canada, there are no regulatory sandboxes on, for example, on privacy, but there are data trusts. And this is something I would like to ask you what your opinion is, and what do you think about doing, for example, a regulatory sandbox for the proposed reforms you have mentioned in your presentation. Thank you.
Thanks. Those are great questions. I'd love to hear more about what Chile is considering. It's such a time of global churn in privacy law. So regulatory sandboxes, like I think that we definitely need to think about how to experiment more and be more agile in thinking about new approaches to regulation. If that means, if regulatory sandboxes are a way of doing that, then in general, I'm in favor. The devil's always in the details, like how would it work? Certainly in the privacy space, like I feel that it's so hard to push people off of that framework of de-identify the data as much as possible and then manage residual risks in a number of ways. And I feel that, if we could kind of allow for some experimentation to say, actually, right, we have these other ways of managing privacy risks. And guess what? We can do it better. We can actually get you more accurate, data analysis with better privacy guarantees if you just trust us in some kind of contained, experimental framework to show you this is what we mean, and let's test this out, right? Because right now, what we see, at least in Canada, is such a conservative, risk-averse view to adopting any kind of new way of thinking about this, and that's really problematic. So if a regulatory sandbox gets you sort of out of those sort of entrenched what have become entrenched ways of thinking about this, then that would be great. The data trust debate, I'm happy you could email me. We could talk about that for a long time. So, I mean, I see data trust personally as more of a kind of governance mechanism. It's more about kind of ways of managing that kind of authorization question, right? Who decides about data flows in different ways? And data trust can provide sort of collective mechanisms for doing that. But in terms of managing the privacy risks, I don't think they're like either here nor there in terms of managing the risks the way that I'm putting here. The one thing I would say, though, is I think that if we were going to get serious about managing privacy risks and bringing in stronger technical methods for doing that, it might be that we need some other forms of data intermediaries. I'm not sure I want to call them data trust, because again, trusts in my mind are just more of a governance mechanism. So, but what do I mean by that? So if I want to, I might bungle this analogy. So if someone actually has the knowledge of this, then you can correct me. But I was thinking, if I was like a researcher and I had to do some testing on biological samples, right? So I collect the samples and I send them to a lab for analysis. And I don't have to know what the lab's going to do. I don't have to inspect the lab. I don't have to even have some really complicated biological sample sharing agreement that takes me 2 years to negotiate for them to test those samples. They're licensed, right? They have all sorts of standards that they have to follow. And I tell them, I want the following tests done. Why can't we do that with data, right? But we would need to create sort of data labs. We need other types of technical intermediaries, and you would need to work out in the law kind of how you regulate those and what they're responsible for. So I do think actually we need more of that kind of thing in the data ecosystem, so that people can just go about doing their business and don't have to become experts about, privacy risk management and whether they're following the right technical standards and what their legal risks are. You say, hey, data lab, right? I need you to do the following things, and they're the ones responsible for managing that. We do this in other areas, but we don't do it with data yet. So I think data intermediaries are really important to think about, whether we call them trusts or what they do. I think we have to think about the technical aspects of managing privacy risks separately from the governance aspects, which for me are part of the who decides kind of authorization questions. Is it the individual? Is it a group? Is it whatever? And those are separate questions in my mind.
Thank you very much.
Thank you. Michael.
You're on mute.
Can't hear you. Let's see, you don't look like you're on mute. You got the wrong microphone selected?
No.
Yes, I got you. We got you. Yes, I can hear you now.
Great. Wonderful presentation. I really enjoyed it. I was curious if you've given thought to traditionally, kind of in privacy risk analysis, we understand it as being connected to potential harms that those individual data subjects may incur through the data processing operations. And this makes a lot of, well, it makes sense, or it's related to our notion of personal data. So we're looking to those specific data subjects to look at who may incur those risks. So I'm curious if you've given thought to how does this notion of risk shift if we've changed the kind of regulatory ambit of being about, privacy being about humans in general.
Sure. So we do talk about this a bit in the paper, because the idea of privacy risk here is not linked to a risk of harm. It's linked to can you learn something specific to an individual. So it's like the differential privacy kind of idea of privacy. It's true that you might say, well, why do you care about that, right? That's a sort of and you care about it if it crystallizes into, violations of privacy rights. And you can think about that in multiple different ways. So you might want to tie that to an idea of harms, like what we're really concerned about are certain kinds of harms. Or you might want to tie it to something else, right? It might be that you don't think it's about harms, you think it's about a kind of capacity people have to, engage in things, whether it's autonomous choices, identity formation, right? There's lots of different kinds of models of thinking about privacy. Some can be harm-based, some are not harm-based. What all we're saying in this proposal is that kind of the entry point to any of that is, the privacy vulnerabilities that we're interested in regulating through this particular principle we're sort of advocating for. It kind of doesn't matter which kind of, what your substantive commitments are going to be to have this privacy risk minimization kind of principle. It might matter, right? If you're going to create a full regime, to that question of what level of risk is okay, right? That again, I'm saying at some point you have to come back to saying, right, is this a context where where 3 is okay, or no, it has to be 7, or right? And that's going to depend on some of your answers to some of those more substantive questions and some of your normative commitments to what you're trying to do. We're agnostic to any of that in this paper. I'm not agnostic to it. I mean, I have my own particular views, but I'm not sort of pulling my co-authors along through that. But also because I think that you can agree with us and have lots of disagreements about some of those other components to a privacy law.
Thank you.
All right. Thank you so much. Sheila.
So thank you, Lisa. Really provocative and interesting discussion, and a really nice way of framing the problem in a different way than the way that I've thought about it. I guess I had a sort of pragmatic question for you. When I think about privacy and I think about regulation, one of the questions I ask myself is, who is it we're going to affect with regulation? And sometimes I think it's the law-abiding, generally law-abiding people who want to understand how to responsibly use their data and how to protect their people who share their data with them, or data that they're using indirectly. But I wonder whether that's the right target. I wonder whether, our risk is with people who are going to abuse the data, who are going to disregard the regulations, and whether we can really build a workable system regulating this way, especially given, to Tegan's point, I think the technology is changing so rapidly, and to Nicola's point, there are data breaches all the time. And so I'm wondering whether it's the case that I'm wondering whether we actually need to amend what we're doing now, or whether we just need to augment it, and whether some of the sort of, yes, we can de-identify, but at least, and so this notion of anonymization is not very effective, but maybe it's a course, it's another course protection against people that we're trying to protect our privacy from. So
is your question like why why not just sort of do what some of the other proposals are proposing, which is sort of, keep the existing framework and kind of amend it a little bit rather than kind of a broad change?
So I'm wondering, and it's a question rather than a proposal. I see the benefits and limitations of both, and I wonder whether and solution that's going to work. I roll through my head of all the different, data breaches and privacy violations, and I understand how differential privacy works, and I wonder whether we're really going to be able to make something that's workable and that's going to and build it quickly enough and change it quickly enough that we're really going to be able to keep pace with the practicalities of how data is collected and used, and how we can interpret it and get use more side information to get something out of it.
Yeah, I mean, it's similar. So we've had some questions. Sorry, I just had a weird feedback of my voice. Okay. We've had questions about why propose something new, right? Rather than just kind of keep kind of shoring up the system that we have. We've had questions from kind of practitioner kind of communities, as well as some other academic groups we've sort of presented this to, and was, pressed as well from someone who's, isn't this kind of a tax on innovation? Like, it's just going to be an extra kind of burden. And I guess I'm of two minds of that, because I don't think what we have now works. And making some of it work is kind of independent, or at least orthogonal to kind of what we're proposing here. So some of it just requires, better remedies, better, investigation powers. Like there's a lot of things, there's a lot of low hanging fruit in kind of privacy law reform that's not discussed in this paper, that certainly would be, acceptable to these proposals, but any other proposals as well. So there's a lot of different things that would go towards kind of, can we plug some of those gaps that you're mentioning? And I guess the question for me is, like, would this kind of new proposal make things worse by adding this additional regulatory burden without any kind of, appreciable benefit, which is very much a concern. I want to say no, but I'm an academic, not so pragmatic. But one of the things that I have noticed is that I think that this determining whether something is personal information or not, and the kind of paradigm of de-identification is really deeply problematic on a practical level and not just conceptually. And that is partly because it's so deeply contextual, you can't create proper technical standards. And so if we want to move towards a system where we can get a little bit closer to having that data lab, so the person who just wants to do the right thing doesn't know what the right thing is, just tell me what to do. Well, to get to that place where we can just tell you what to do, so you don't have to like hire a lawyer to tell you it all depends on context, and now let's spend a year negotiating a data sharing agreement. To get to there, you need better technical standards. And to get to there, we need to have a better way of managing, thinking about how we're going to manage risk, actually. And so it is a transition that we're asking for, but I think the end result of that transition helps ordinary people better than the current system, which is so context specific, doesn't scale, doesn't lend itself to technical standards, lends itself to a lot of risk averse decision making, makes a lot of work for lawyers, not interesting work, and costs a lot of money for people who have to hire them to do that work. And there's a better kind of infrastructure that we can put into place, but we do have to put it into place, and that will be a cost.
So yeah, thank you. So I see that. I see all the great benefits of framing it this way, but I also wonder about, I just worry about who we're protecting ourselves against, and certainly that group of people who want to do the right thing need to be serviced. But I also want to protect the people the nefarious people and criminals, or opportunists who are not going to play by the rules. And how do we protect ourselves against them? And maybe it's security. I mean, maybe security. I mean, Nicola talked about this too. You know, you can't have privacy without security, and maybe we need to focus more on security as well as to shore up where we can't achieve privacy. I don't know, but I defer to you. I'm not an expert. Thank you. Yeah.
Thanks, Sheila. I've got Benjamin, Avery. I'm not sure we'll get you. This might be the last question, but we can find another time. Thanks, Benjamin. Go ahead, please.
Thanks. I really enjoyed your talk. I was wondering if your solution sort of addressed another worry that I've had about de-identified data, which is that sometimes the worries are not so much that I can be identified individually, but that like people can learn things about my group and then use that to like learn things about me from innocuous data that I give off, right? Like Facebook. You know, my data doesn't need to be in the training set for their machine learning algorithm for them to figure out very personal things about me on the basis of it. And I was wondering whether the approach you're suggesting tackles that sort of problem as well, or whether that's just a separate issue that would have to have another sort of solution.
Yes, no, awesome question. Thank you, Benjamin. Nice to see you. Yeah, so I think that if you switch to an architecture, a regulatory architecture that's about regulating information about persons rather than personal information, it's actually way easier to get at some of these sort of profiling type of concerns, because they don't fit very well in the standard FIPPs framework, because the FIPPs framework is all about, you know, the personal information about me, whether it's accurate, my information is accurate, whether it's being used to affect me in certain kinds of ways, right? But we know that, yeah, you can have information that's not even identifiable, that's used to create a model that then is applied to me in a particular way. Or you could use my information in order to create a model that applies to other people. Same with the accuracy requirements under FIPPs. So one of the sort of principles is around, you know, that the data has to be relevant and accurate. But again, accuracy requirements and the worries that we have about models being inaccurate aren't necessarily about the data, the specific personal information, that my information is accurate. You're worried about, you know, the model itself or the data set itself that might be about other people. All of these are very difficult to shoehorn into the FIPPs framework. And if you look at kind of how the regulators do this, even with online behavioral advertising, it's like through all these really weird kind of moves. It's like, well, it's sort of personal information. Well, it's not. We're going to treat it like it's personal information, even though it's not really personal information, because, right, it's just like these kind of crazy interpretations. So if you switch to the framework that we're seeing as a kind of basic architectural change, it's way easier to get at some of those considerations. It's way easier to get at group considerations as well. It's easier to incorporate things like collective rights around data. It's just easier to put all of that into the same framework. And so you kind of, you still can keep the individual kind of, you know, questions there, but they shrink and you make space for kind of comprehensive regulation around some of these other issues. So yeah, you're absolutely right.
Super. Thank you so much, Lisa. That's just a terrific presentation and a really stimulating conversation. Thanks, everybody, for joining us. We have dropped into the chat a 1-minute survey. We'd love it if you'd complete that, as we're trying to continue to improve our processes here in our seminar. So please click on that before you leave so you can have it open on your browser. And please join us next week, talk by one of our newest faculty fellows, Jason Plack, on R2D2 versus HAL 9000, specifying psychological features of robots that encourage and discourage human trust. Sounds like it's really going to be fantastic. So I hope I'll see you all next week, 3 p.m. Thanks again. Good to see you all. Bye, everybody.